Stone and Solace law firm. But I also wanted to read his bio to give him a brief introduction before I let him take it away. So Blake Slater has extensive experience. Wow, let me back up. Way too excited. Blake Slater has extensive experience practicing law in many diverse areas, which include general litigation, dispute resolution, estate planning, real estate, business, trust administration, and probate. Mr. Slater previously worked on a national law firm representing claimants applying for Social Security disability benefits all over the country. Mr. Slater utilizes a practical, cost-conscious approach to deliver personalized and comprehensive counseling for every client matter. Mr. Slater is active in the South Bay real estate community, where he's conducted countless lectures and provided legal guidance to many organizations, such as the South Bay Association of Realtors, now PVPAR, Harcourts Hunter Mason, Compass, and more. Mr. Slater graduated from Whittier Law School in May 2012 and became licensed to practice law in the state of California and the United States District Court in December 2012. Mr. Slater served as the law clerk in Santa Ana Superior Court. Mr. Slater also graduated from University of Arizona with a degree in economics and a minor in business. So Mr. Slater is originally from Gilbert, Arizona. In his spare time, he enjoys singing, karaoke, attending concerts, playing board games, and winning fantasy football. So with that being said, I am honored to present Blake Slater to you all. I'll let you take it from here.
Thanks, Chanel. I keep trying to get her out for karaoke, but she won't take me up on it. But one of these days, maybe depending on how I do today. So I appreciate.
You don't want me at karaoke.
That means I definitely want you there. Appreciate the kind introduction. Definitely don't like being called Mr. Slater so many times. So I am Blake. I'm an attorney at Stone and Salas in El Segundo. We're a full service law firm. I won't repeat the same things that Chanel introduced me about doing, but I appreciate Chanel inviting me and the PVPAR for having me. I've done these a lot. I always enjoy them. This is actually my favorite talk, so I'm happy that they picked this one for me to kick off with you guys about and you guys I like the name too, Real Estate Legal Nightmares, Tales from the Litigation Trenches. And so, I attended a couple installations recently, obviously tried to stay involved with the realtor community here in the South Bay. And I wanted to kind of give some stories, not just to scare everybody, to make sure that you call me, but often what happens, the way that I approach, or my thought about how to make the most out of my time with you and your time with your clients is you want to think about ways to stay relevant, to stay in touch with them. I know that a lot of you get asked questions, whether it's during transactions or after transactions, that can make you feel a little uncomfortable or like you're being asked to give legal advice, right? It could be as simple as, how should we take title? Should it be a joint tenancy? Should it be community property with right of survivorship? What's the difference? Should I be incorporating? Do I need to incorporate? I'm going to buy this income property, and should I be forming an LLC? Or if I put my property into a trust, does that protect me? Is that legal protection so somebody can't sue me? These are all basic things that I know realtors get hit with all the time. I always try to make myself available if your clients, start to go down that road, to give you to be dangerous, to kind of know generally what the answer is. But often what I say, and I want to empower you guys to say, is that the most annoying thing that an attorney can say to a client is, you know what it is, Chanel? I think she got it. It depends. I may have said that to her once or twice. But I want to empower you to say that. So when they ask you for the hardline answer, it's always got to be, it depends, because it does. Because I could come up with a million reasons on each of the questions I just asked you why there is no right answer. It depends on, usually what it depends on is who's involved, what type of property it is, what their financial advisor says, who's the deep pocket, who is going to be taking care of the actual heavy lifting, Are there children involved? Are there going to be children involved? There could just be a million things that'll affect the analysis when they say, how should I take title? And so what I always try to start with is to empower you all to be annoying like me and say it depends, but confirm with your clients that you know generally what the options are, what the questions that need to be asked, but also you want to make sure you have professionals around you that you trust, that are available, that you could send them in the right direction. So that's just kind of an overall approach that I have in any of my talks. With respect to today's talk, and again, I'm happy to speak at you. Rick and Janelle mentioned I'm here for an hour. I've done this for different brokerages and different associations for up to 2 hours. So I could definitely, run my mouth. But if you guys have questions or input or something I'm saying doesn't make sense, usually I'm asked to speak a little bit slower. So I'm going to try and incorporate that right now. But definitely send in chats. I think the chat function is on. I don't know if somebody's looking at the Q&A, but as I kind of go through some real estate litigation stories that I've collected, I'll be I'm certainly happy to answer just general questions. So don't be afraid to ask me about a specific question you might have been asked by a client or a litigation horror story that you think is coming. But again, full disclosure, I may tell you it depends in terms of the answer and tell you we got to get into it offline. But so first I'll start with a couple of just high level things of recent current cases that we are dealing with right now that I think none of you would believe could happen, but just might. And you might, I'm sure nobody here would be the type of realtor that would get into this mess, but just some issues that we're dealing with right now. I have clients who came to me last week who showed me escrow documents of an escrow that was opened up 6 months before they had signed a listing agreement. And then when reviewing what the instructions said, there were a bunch of bogus claims in the escrow document for money owed to third parties who didn't exist. So essentially showing me paperwork that someone that represented them was trying to sell their property and offload a bunch of equity to parties that didn't exist. So that's going to be an interesting lawsuit. I recently got a referral from a realtor who was helping with the lease agreement, helped a landlord with an income property. He was very educated, not in real estate, but got a lease and moved a client in to the property. And it was disclosed in the agreement that there were known mold issues. So when he came to me, what we wanted to deal with was going after the HOA because like for a year he'd been complaining to the HOA that upstairs some leak, that it's like the roof is like kind of caving in. There's like a huge bubble and obviously just a leak that's going to be creating mold issues. And so we came in to talk about going after the HOA. But then when he told me that he just moved a tenant in there and put into writing these known issues, I had to convince him that the most viable lawsuit is not the one against the HOA, but the one that's likely coming against him by the tenant. So definitely got to be careful with what we put into writing. And I also had recently, I settled a case where there was this property manager up in NorCal who had taken over for one of their parents, this longtime client who lived locally, and told the owner, when it being my client, that the rent was being increased over years, over like a decade, but only told him that it was being increased by a fraction of what she was actually increasing it. And so he went to go sell the property, sent the realtor, a local realtor up there to go around, get the estoppel certificates from the tenants just to, to firm it up and see what was going on. And then when we took a look at, when they took a look at the leases, the increases had been substantial. The property manager only took cash, and so essentially was saying, I increased the rent by $50, but really it was 500, and she'd been doing it for years. But since it was only cash payments, and the client was down wasn't in NorCal, he trusted her and didn't look at it. So I think that would be a pretty awkward conversation that you don't really want to have with your clients when all you're doing is trying to sell the property, and then you uncover a massive scam. But we caught her and got her on the record, and the client was happy with the outcome. So often, again, when I'm thinking about the types of issues that often you fall into, or again, things that you could be thinking about reaching out to your clients and saying, hey, I attended this talk with the association, and this lawyer came in and told this crazy story. These could be ways just, again, reaching out when I stay relevant with the clients, let them know that, we're thinking about them, and there might be, more work that can be done, or getting things updated, those types of things. I had another one where you probably maybe couldn't believe, where again, the realtor didn't do anything wrong, but kind of found themselves in a kind of insane situation where there's a son whose stepfather passed away, and his mother has mental issues. She's old. She can't take care of herself. So he moved. The son moved her out of the family home where she lived with the stepfather into his home. So the son's taking care of him. Engages a realtor. The realtor goes and starts staging the property, moving all the stuff out, selling a bunch of the stuff, staging it so that they could sell it. And then after the realtor sets up the open house, what happens? The client, the brother's sister-in-law, the brother's stepsister moves into the property, changes the locks, and says, guess what? I live here now. And if you take a look at the trust documents, the sister, am actually named the trustee and not you. So I have the legal authority to do whatever I want to. And so again, it was a very awkward conversation that I spoke with the realtor, confirming that they had done nothing wrong, that there's people like this out there in the world. But again, the son moved the mother out of there so he could take care of her at home, and literally take care of everything, bathing, feeding. She just needed full-time care, which is why he needed to sell the property to put her into a facility where to be taken care of. And then the stepsister comes in and says, you know what, if you look at the trust, I'm the one who should be calling the shots. I think it's in mom's best interest that I live here. And so that became a massive lawsuit. And I told the client, the son, who was very disturbed, obviously, by what had happened. But I told him she really gave him a gift because if you think about it, on what planet is a judge going to agree that her taking advantage of an open house to change the locks and move her family into the property would be in the best interest of the mother who needs the money? And so what it sets it up for is a petition to challenge who the trustee should be. Generally, it should be somebody who puts the beneficiary, the mother, as number one, as the person that we're taking care of. And anybody who abuses that trust, does those sorts of things, can be removed to put somebody else in place. Could be sued for punitive damages to punish them for such despicable behavior, but also could potentially could ask the court that they not inherit anything. And so she may have risked everything by doing this. And I'll say too, there was an attorney that's representing her. You will also find attorneys that will step into these situations, and everybody deserves a defense, but you might be surprised how which side some of them find themselves on. And so what am I talking about here? Like when you're speaking with your clients, and again, this was the realtor didn't do anything wrong, the son didn't do anything wrong. Somebody did do something wrong, and it was the parents. What often happens is people have an idea of how their kids are going to get along, or a faith that when the parents are gone, everybody's going to play nice. I always tell clients, you got to think about your legacy. So this is something to think about if your clients or friends are asking you, who should we be putting on as a trustee, or when should the kids get it, or hey, here's another one that I hear a lot. Hey, let's see if let's put the business-minded kid as the trustee, but in the documents, we'll even it out that the business-minded kid didn't really help with the family, and so there'll be we'll fix it in the inheritance. And I had a case like that where a client came in and she'd taken care of her mother until the mother died, and then she just the daughter taking care of the mother was just she was like a housewife. Like she took care of her own family, like with her husband, and then she moved the mother in, took care of the mother till she died, and just wasn't sophisticated in trusts and all that. And then her sister was the business-minded one, the one with the education and blah blah blah. And so the mom thought that putting the business-minded sister, who was more educated, in charge, and maybe would be less emotional, put her in charge of as the trustee to distribute the assets. And so when she came into me, the daughter, she was like, mom died 2 years ago, and my sister still hasn't given me the property. Like, I don't understand. Like, she keeps telling me it's for my own benefit and whatever. I just don't understand. And so she brings in her stuff. I review it. And there was a standard provision in the trust which said, again, taking the step back, mother is taking care of, daughter is taking care of the mother at the family home. The business-minded sister has her own family and her own money. And so the way that the mom broke it down was, well, the house goes to the daughter who took care of me, the house where she took care of me until I died, like that, she gets that house. And then anything liquid goes to the trustee, to the other daughter. But then if you looked at the numbers, the difference, it was essentially 600,000 in terms of equity in the house and 400,000 in liquid. So, it's uneven, but if we look at it, we say maybe it should be uneven because the one who's getting the 600, it's the house where she took care of until she died. But the standard provision that was in the trust was, if the daughter who lived at the house dies before the trustee daughter, then the trustee daughter gets the house. And so I had to have the very awkward conversation where I was just like, look, I don't know what her game is, your sister, but there is a provision in here that says that if you pass away before her, she gets the house. Now, legally, that's not how it's supposed to happen. Legally, like, if you brought that to court, obviously the idea wasn't that the trustee could just hold on to the house for as long as she wants. But if you don't enforce your rights, you lose them. And so I told her, I was like, look, I'm not saying your sister is evil, but like, why else isn't she giving you your own property, right? And so I said, look, we got to get on this. Like, now that we're talking about it, like, we got to do it. Let me, review your stuff, lawyer up, turn up the legal machinery. I sent a letter, a very nasty letter to the trustee, and then I spoke with her, and she took this position that was very she didn't like being called out, but she took it like, oh my God, like, yes, of course, like, no big deal. And I said, look, I'm not trying to like, there's a bunch of things you got to do in a trust administration, right? You got to give proper notice. You got to inventory the assets. You got to do these deeds. You got to do a bunch of stuff. And I was like, I'm not being hired. I can force you to do all this stuff, but I'm not being hired to do that. She wants the house. So how about this? I'll draft the deed. You give her the house. We'll sign a settlement agreement and we're done. That's it. And she said, yeah, the sister said, yeah, let's do that. So then I charged my client to draft the deeds, do the settlement agreement, send it over. And what does she do? What does the trustee do? She lawyers up. And so, and it was funny initially, one of the things that I say, and I take it, each of you has maybe learned this, is that clients, I often find professionals who are like themselves. And so this is something like, often, realtors will be like, I want to be your number one referral, handle all your clients. It's not a one size fit all. And I'm not a good fit for everybody. I'll tell you that. And the reason why is I know what I offer and I know what I don't. I don't offer guarantees. My whole thing is it depends. So if you want someone who's going to say, Blake, like, and I've had this happen where I say, XYZ, I've got the case, whatever. And Blake, you think we're going to win? And I'll say, it depends. And I'll get this. Do you not believe in my case? Like, are you not comfortable? Do you not know the law? Like, why are you not confident about the outcome? And my response is, look, I don't have control over the outcome, right? I'm going to advocate and do everything I can for you, but so many things that are in the way of me accomplishing that goal that if you want to guarantee, I'm not your guy, like period. And so back to this situation, lawyer steps in. I'm like, okay, great. I get the dumb trustee who's taking advantage of her sister out of the way. You guys are going to play nice, right? Because I've got like this. There's nothing here. I even had the emails saying she's going to give the property, so she knows she's supposed to give the property. Not what happens. These people look at it as this law firm looks at it as not a gold mine, but hey, an opportunity to do some work. And they start the trust administration process, even though everything's been distributed. It's been 2 years. I'm telling them, like, we're the only heir, like, no work needs to be done. Whatever. I look at it as, well, we get the real estate. The trustee gets the liquid, the cash. It's just coming out of her pocket. It's not coming out of our pocket. We're getting the property. Like, it just doesn't make any sense. Fine. You do the administration, and then the true colors come out, and I get a demand letter from the attorneys representing the trustee who say, based on California law, the trustee is supposed to make good use of all the trust assets. And the home your client is living in is still a trust asset. And so we got to do our due diligence for the next 4 months, because it's standard. If you give written notice to everybody, that they have 4 months to contest it. So your client can either pay fair market value rent to live in her home, or she can move out, and then we're going to get a tenant in there. And I stopped with the writing, and I get on the phone with them, and I was like, you understand that you are asking my client to move out of her inheritance so that you can collect money. Like, that's your position. And they said, that's what the law is. So we filed a lawsuit. And we sued them to get punitive damages, get back her attorney. Because now it's like, all right, well, you didn't do the administration properly. Now you're forcing me to do the thing I didn't want to do, which was over lawyer this thing. And again, it's one of those things where it's like, I went to my client and I was like, look, this is why people hate attorneys. Like frankly, it was just so bizarre, the things that were being put in writing to me. I have to turn to the client and say, I am sorry. Like, I tried so hard to avoid this. But again, for me, because I approach it that way, often when the stuff hits the fan, I don't have to do a bunch of explaining as to why we got there. I try to low key all the time. I want to settle stuff. I don't want to litigate it. Like, I want to get out of your lives. I don't want to keep talking to you about all these depressing things that anger you. I want you to move on and go make some money and live your life and not have to think about this stuff. So what happens? We filed the lawsuit. They defend it. They say, they had to do it, blah, blah, blah. 4 months and probably $20,000 later, they do exactly what I asked for. They sign the settlement agreement, give her the property. I mean, just totally insane. And again, we could have kept going. I could have proven that it was in bad faith. We could have gotten punitive damages, but I turned back to the client and I was like, just save the money. Like, just don't, like, let's just settle it, which is what we did. And so, again, the big picture that I often talk to clients about when they ask you, or when they ask me, and maybe when they ask you, look, I just bought this property from you. I'm going to put it into a trust. Like, what should we do? Like, when should the kids get it? Who should be in charge of it? And it's really a soul searching question. It's not one that we should just say. We shouldn't say just the oldest. I had a guy came in who he said, I'm going to put all 3 of my kids, adult kids, on as trustees, and anything they do, it has to be with unanimous consent. And I told him, I asked him, I was like, do they get along? And he said, no. And I said, okay, well, you understand that you're going to die. And then you're going to put these 3 that are already going to be pitted against each other, that then attorneys are going to be making the money. That inheritance that you're leaving them, when they don't get along, you're already telling me they're not going to get along. The lawyers are going to be the ones getting paid. And he said exactly why I think they're going to work together. And that's how we did it. But I personally would never advise to do it that way. Here's what I would have done. If there's 3 kids and they're going to be inheriting it, and that none of them get along, or one's a jerk. I've had it with drug addicts. I've had it with just a bunch of stuff. Then put a neutral third party in there, because they're gonna make money off it anyways. But at least it's not at the sake of risking the relationship with the kids, because this stuff, I mean, it gets way gnarlier than people want to believe. um I had another one where it was a husband and wife. They were, I think, it was their second marriage, and then the husband died, and then the woman lost touch with the kids from the previous marriage. They just didn't have a relationship. They would never call their stepmother, wouldn't take care of them. And she came to me and she was like, I want to make changes to this estate planning thing about what they're going to get. They were going to get like 150,000 between the two of them. I want to give them 50. And I looked at it, and the way that the deceased husband drafted it, she could do it. So we did. And then she passed away. And then guess who shows up to the funeral and asks the niece, where's our money? Like, at the funeral. Like, this is how gross these people are. And she knew. She apparently knew that it was going to happen like this. And of course, then the niece comes back to me all distraught on the emotional stuff, obviously showing up and asking for a check at the funeral is just disgusting. And I said, don't worry about it. When we give them notice, they'll know exactly what they're getting. Give them notice. They lawyer up. And I get this guy, sending me demand letters going, oh my God. And literally, I went to visit the client. She was in a home, but she just had a bad heart. There was nothing mental about it. She was smart as a whip. I spoke with her multiple times. I met with her multiple times. Like, I was the guy who made sure we were on the same page about what we were doing, and visited her, and we got it notarized in the home while she was hooked up to the heart machine. And she passed away within a week of it. And so this guy comes out of the woodwork, and he's like, oh yeah, undue influence. There's no way. She was so old. We want the medical records and show us that, they didn't take advantage of her, and whatever. And I got on the phone with him and I said, look, you do what you got to do, but you don't know your clients. I know them. I now know them. They showed up at the funeral asking for the money. You've seen the trust. You see that she could make the change. I'm not giving you her medical records, because guess what? If that's the route you're going to go, when you have no basis, if your only basis is you're pissed because she didn't get enough money, then take us to court. But I'm telling you what you're going to find. What you're going to find is she wrote them out because they're terrible people, and she was allowed to do it. And then guess what? They're going to lose their entire inheritance, right? There's a no contest clause. So go. I said, take us to court. I don't have to answer any of your questions. I don't have to do anything. My client told me to be a brick wall. I'm a brick wall. And guess what? They took their money, right? Because they knew they knew not just legally that it could happen, but practically, obviously, it made no sense if all you're doing is running your mouth and saying, this isn't fair, I'm going to scare you to pay. And I have clients who are happy to negotiate with the terrorists. And I tell them, if you want to pay them, be done. You don't want to pay me, then do it, because there's no guarantees. But this is one where they took a hike. And it's something that's important to think about. Think about your legacy, right? Because the way that she did it, the way that the client did it, is the way I tell clients to do it. A lot of the times, and you may be thinking about it, or your clients may be thinking about writing somebody out, right? I had a client who came to me. She got a check from the lawyer for $1. This is not the way to do it. Okay, you have to give them something. Even if they're pieces of trash, even if they're, they don't mean anything to you and you hate them and you want to stick it to them, because what ends up happening? It happened in this case. I just told you, she did it right. She gave them something. So there was an incentive to not litigate. If you give them nothing, the no contest clause means nothing, right? They're not losing anything. Really, what they're going to do, if you give them nothing, you're incentivizing them to go find some lawyer who's going to write a demand letter and create all these issues so that you'll pay them to go away, because then they can leverage, you're going to pay a bunch of stuff to fight me, so why don't you just pay me and we'll go away. But if they're risking losing their inheritance, 5, 10, here it was 50,000, then if we put up that wall and say we're not biting, then they may go away. So that's something that that I see all the time, where clients, they're real excited to, stick it to the ex or stick it to the, the kid who was never there. And it's really just not the way to do it. You're setting up issues for everyone else. Okay, so let's talk. I did a lot of out of estate planning stuff. Let's talk about when clients come to you and they, what the situation is, right? I had two matters that were going at the same time, where it was they weren't married. I don't think either side was married. It was boyfriend and girlfriend, and the boyfriend was out of the divorce, and his credit was destroyed, and the girlfriend was the deep pocket. She was the one working, she was the one with the money. And so what they did was, when they purchased the property, because again, there's two couples at the same time, because the boyfriend had like a bad history, bad credit, and whatever, he couldn't be on title. He had to disclaim it to get the proper rates and whatever it was. And then what ended up happening is they live at the property, right? So they come to you, they're saying, we're going to purchase this property. Like, do we have to be on title, or boyfriend, girlfriend? Are there any protections? And what you're going to say is, put whoever on title that gets you the best rates, that gets you the best money. Like, it's not really a realtor thing. It's like, it's just a practical thing of what gets you the best rates, what makes the most sense. But it turned into legal issues when both women were on title, and then on one of them they just broke up. They just had a bad breakup. On the other one, the guy cheated on her, and so it became a very contentious thing. But then you look at, well, who gets to live there? Well, who's on title? Not the boyfriends. And so both of them within the same year became this problem, where it was like, yeah, practically when you purchase the property, it made sense to do it this way. But what happens if it doesn't work out? And they hadn't thought about that. One of them tried to be like, oh my God, I can't believe, my realtor didn't run me through this. And I was like, what does this have to do with your realtor? Why would your realtor run you through this? This is you not thinking about what I tell clients is, you want to think during the honeymoon phase, you want to think about the divorce, right? It is really the way to look at it. Is while we're getting along, let's talk about if we don't get along, because that's the best time when people will just be signing and happy-go-lucky. Or if you try to do that during the honeymoon and they give you the stink eye, then maybe you're figuring something out sooner. But so with both of these, one of them was during the pandemic, and again, the guy who cheated, the girlfriend flipped, obviously, and was like, get out of my house. And he was like, this is my house. And she said, no, it's not. So she didn't want to be around him anymore, and she went to go stay with her parents while she instituted an eviction against him. And this was crazy because she committed perjury, because she said, look at title, I'm untitled, this guy's my tenant. And she went to a like a mill type firm, who's just like, all right, that's the tenant. Oh, these mortgage payments, sure, they're rent. Even though when I got involved, I said, look at the Venmo, they all say mortgage. How did a bunch of his money went into the down payment, a bunch of his money went into the upkeep. The mill was like, well, they said it's rent, so if he's not paying, and he stopped paying the mortgage because they're breaking up, and she's threatening him with the house. But so she started an eviction, 3-day notice, non-payment of rent, and it's during the pandemic, right? And so he has to pay me a bunch of money at this mill. We're fighting it, and they're sending, a bunch of discovery, like they're just drowning him and stuff. And we had a way out. We had a way out to just stop it during COVID. I don't know if anybody had an income property, or you had clients who were trying to do it. You just sign a declaration and you say, hey, I can't pay. And we could have done it and stopped the eviction in his tracks. But I told him, I said, look, you do this, you will now have paperwork that says you're a tenant. And then if you want to go and do what we need to do, because let's take a step back, right? What I wanted to do is, even though you're not on title, you do have rights, okay? Because there was an understanding that they were purchasing it together. We can trace the fund to show he paid for the down payment, he put a bunch of money in the upkeep. So if she's running away with the house, then he should get that money back. But you can do that. You can sue for that. But those lawsuits take years, right? Right now, in front of Judge Frank in Inglewood, he's setting stuff out to the end of next year. That's how trials are already over almost 2 years behind. And so I told him, I said, go ahead and sign that document, but you may lose your claim to the house if that's how you want to do it. I was like, you're committing perjury, so like it's up to you. If you want to do that, fine. The eviction will stop. But how are you going to get your money back? So we followed the legal advice. We didn't do that. We filed our lawsuit for breach of contract with respect to the house. Dragged her into court. We were able to negotiate a settlement. We stopped the eviction because once we got involved and we said, look at the documents. Like, this is not rent. He is not a tenant. It doesn't matter. You can call it whatever you want, but there is no landlord-tenant relationship here because they were boyfriend, girlfriend, X, Y, and Z. And then once we got in front of the judge, they backed off. And we were able to negotiate a settlement. It was the same thing with the other guy. Again, they just broke up. And she just threw all this stuff out in the carport and said, "Come and get it. Like, see you later." And he kind of took a bath on that one because the ex had a good relationship with the daughter. He didn't want to do a bunch of litigation. We settled it. But so back to like you and the realtors, and when you're speaking with your clients, you know, there's practical considerations as to why people might take title. How you should do it. It depends. It just depends on, because you can't forecast, that you're going to cheat on your girlfriend. It's going to become this whole thing. But you have to know that there are rights and ways that being on title can be used against someone if they're not on title, even if it makes sense. Somebody purchases a property. You guys might deal with husband and wife that are from they each had previous families, and they have their own sole and separate property, and those types of things. And they're like, well, hey, I titled it in that way. That means that if there's a breakup, like he or she doesn't get anything if we end up getting divorced, right? And it's like, it depends. It doesn't matter. It doesn't matter how you title it if that's not how you treat it. So if you've got someone, if they come to you and they're like, hey, Chanel, we're going to be purchasing this property and I want it to be sole and separate. If I just title it in that way, I'm good, right? And the answer is no. That's proof of what the intent was. But if you're using community property funds, or if you title it that way, but they give a massive payment towards the down payment, if something happens, they're entitled to get that stuff back. So it's way more complicated than just is titling good enough? If I do this title, I'm all good. But one that I definitely get a lot that you might is, hey, I put this into a trust, so if something happens, it's like a separate entity. I'm protected from legal liability, right? And the answer is no. It's different if you put it into an LLC or a corporation. That's a separate business entity, right? If you put it into a trust, it's just titling for estate planning purposes. All that deals with is if somebody dies, then if it's a title in the name of the trust, then it's an asset of the trust. So if the person who dies has that property in the name of the trust, then it gets distributed to their heirs based on its terms. That's it. So if you've got an income property, if your client has an income property, and they put it into their trust, and they say, hey, you helped me purchase that income property. Blake, you sent me over to Blake, and I put it into the trust, but now I've got, now it's separate, right? If something happens, there's a slip and fall, they can't come after me and my family, right? Because it's in the trust. That answer is no. There is no it depends. But this is something that often your clients may be confused on, or just a misnomer that putting it into the trust protects you legally. Now, there isn't, it depends, I guess, as I say that, of course. If it's an irrevocable trust, which is a very specific type of trust, that it's in specific situations where you actually lose control of the property, that could shield you from liability. But that's not, that usually where that happens is if you've got parents, the common thing is, or the common situation is parents with special needs children, who the parents have assets, and the kid's going to turn 18 and is going to be an adult. You have to make sure that your assets are not being used against you when you're applying for government funds. So you put into the irrevocable trust, I don't own it, and so now now the government can't look at it when they consider whether they qualify for government aid. So it's just very specific, very uncommon that you would just put into an irrevocable trust. So it's very unlikely that it would create any kind of shield, any kind of liability from you at all. I'm in the middle of another one where a guy I don't know. He says he didn't understand the laws, which is probably true. But he put his girlfriend on, put his girlfriend on title, joint tenancy. Something happens to him, she gets the property. And he put all the money in and X, Y, and Z, and she kind of lived there and but never put any money in, never took care of anything. Always made him pay for everything. And then they broke up. And then she filed a lawsuit, a partition lawsuit. She says, "Hey, I'm a 50% owner. I get 50% of the house." And she's trying to throw him out of his own house. And it just, I have clients too who are like, Blake, or you may hear this, right? Oh, you guys are trying to send me to Blake. He wants to do a trust. Like, I'm just going to put my kids on now. I'm just going to transfer the property to them now. They're going to get it anyways. Why do I got to pay some attorney to do that? Well, you know what happens when you put somebody on title? They can create a bunch of problems for you. They can, and it doesn't even have to be nefarious. If you're on title, bad guy could find that person and say, "Hey, they got this asset. I'm going to go collect on it." It could be as simple as that. So if you ever have clients that are telling you I could handle it my way, it's just something to think about. That there's just so many moving parts. There's so many considerations that again, I want to empower you to play dumb, but really we have to play dumb because before we can answer any of these questions, we got to make sure that we understand what the goals are. I think it's already been 40 minutes. So those are some of my talks. I don't know, nobody's asking any questions. Chanel, you have any questions or anything? I got more horror stories to talk about, but.
I just want to open it up to the group. Does anybody have a specific situation that they want to ask Blake about?
You got me now. I'm not billing, guys, so I may do some punting, but if you got any questions for me, all
Hey,
right,
Blake,
Alan,
hold
go ahead.
on. I got one quick question in this. It's a situation where somebody was in escrow for a property, got approved for a loan, and it was a condo, and ended up that the insurance wasn't sufficient to meet Fannie Freddie guidelines for the loan, and they went past escrow period, and I guess they removed some contingencies, and the listing agent is trying to keep the buyer's deposit and send him a cancellation notice. So the question I think is, in that situation, is there some kind of a disclosure issue where they didn't disclose the insurance, or should they have done just more due diligence on the insurance?
Yeah, so good questions, and I'll open with I think the obvious answer. It depends, right? So the timing of the stuff, what was disclosed and what wasn't, but if this is the whole point of having those contingencies, right? So whose fault? And I'm not telling you to answer it, but whose fault was it that the insurance wasn't proper to meet the meet the needs for the transaction? And was it if they always knew they were going to get that answer after the contingencies were being lifted? I mean, these are setups for them to say, "Hey, if you're going to want out, we're going to cancel it because you couldn't meet it." This is exactly why the deposit becomes at risk. If you're not abiding by the contract, meeting the deadlines, getting the information on time, then it could be that they are entitled to it. So it could be a disclosure issue. It sounds like really what that comes down to is if and here Anastasia is asking if the loan contingency was waived. It sounds like they passed the period, right? That it was waived.
I do. Again, I was not involved in the transaction, but somebody was asking me, and then so I do think, obviously, if the contingencies are removed, they're not going to keep the deposit. So I do think that because you probably were removed based on the loan approval, the lender did release a closing disclosure, et cetera, and then it ended up that the insurance didn't meet Fannie Freddie guidelines.
Yeah. So that could be a real ugly situation. And again, these are those things you guys are balancing a lot. We need to get the deal done. And I always tell clients, I was like, they're working for you, but we got to get the deal done. And so when you've got your own people, whether it, the mortgage companies or it's insurance company, where whoever you're working with, they all got their own hats in the ring for this type of thing. Anastasia agrees that they're going to lose the EMD. And again, it depends. We got to look at it and the timing and that sort of stuff. But these are those things where what I tell clients is if you're going to Alan or you're going to Chanel, like use their people. Like, I've got my people. I use my people because I know they're gonna, if things go sour, that they're gonna be on my team. And so if they're going to the realtor, going to you guys, I'm always saying, and I think you guys know this, right? When you're trying to pick escrow or who's doing the disclosures or whatever, whatever it is, I always tell my clients, use their team, use the people they have a connection with, because when you sometimes are dealing with a moron, but if you're just dealing with a moron and they create a bunch of problems that don't make any, that out of nowhere. I had this case where it was a realtor who came to one of my talks, and he met this, there were these two neighbors, and the neighbor wanted to purchase the other guy's house. Okay, super easy. And like the house was dilapidated. There were vagrants. The police kept getting called to it. Like the guy who owned it lived somewhere else who wasn't taking care of it. So the neighbor's like, I want to purchase next door. I want to level it, and I'm going to have a much bigger house. So they came to a deal. The realtor is working the thing. They signed the listing agreements. Then he pulls title, and he finds that the guy who owned the dilapidated place, he had owned the property in joint tenancy, and his wife had died. But before she died, unbeknownst to him, she had deeded her 50% interest in the house to her daughter from a previous marriage. So now I got a realtor here who's got a slam dunk, like both sides are on, they've already agreed, they've signed everything. He pulls title and he goes, what the hell? Like, who is this person? Like, there's this and the neighbor didn't even know. He didn't even know that it had happened. So they come to me, and they think she's dead. Like the guy doesn't know anything about her, can't find her. But I tell him, like, look, you got to go to court. You got to get her off title. Like she owns 50%. It doesn't matter that your ex, that the widow, your deceased wife didn't tell you. She's allowed to do that because she was on title. So we're about to file the lawsuit, and it was around the time when some of the major companies got hacked and a bunch of their records got released. And I was doing like my last minute due diligence. I was just doing some Googling, and I found where this lady worked, and her phone still worked and her email still worked. I actually think we had already filed the lawsuit, a petition to get a court order so we could sell the property. And then I get a ping. I hear her voice on the voicemail, and I call the office, and we mail. And I'm like, I send a process server to go serve her, and they accept it. And then I get a call from their litigation counsel. They're like, we don't accept lawsuits on behalf of employees. And I said, cool story. I don't care, because I have a proof of service that says that you took it. But just so we're clear, like, I don't want this to be a lawsuit. Get her on the phone. Tell her I'm suing her, but all she has to do is sign off on the sale, and she's going to make $150,000. Like, I don't have to now that I found her, I don't have to litigate it. She never showed up. And so we had to continue with the lawsuit. And then here's where, to what Alan and what I was thinking about in terms of having have people around you that you trust and that you know, because we proceeded by default. We're going to get a court order from Judge Hill, who is a good judge. She just retired, but she's going to give us what we want. But I told my clients, I told them, like, hey, here's what I'm going to give to the judge. I want to make sure that when I get this signed by the judge, it's going to help you sell this. Like, I don't care what's in it. I'm going to put my legal stuff in it, but what does title need to do this, right? We got a girl who were defaulting and X, Y, and Z. Like, here, I sent them the draft. I said, I want you guys to approve this before I go to the judge, because if there's something more you need, just tell me, I'll put it in. I don't care. And they said, oh, we don't do that. We don't until we'll review it once you get it back. And I turned to the clients, and they were pissed at me. They were like, why are you creating more work? Why are you communicating with them? And I said, look, here's your email where I'm saying, this is why I did it. This is what the goal was. I file it, immediately rubber stamp, they get it back. Here's your judgment. We got everything we wanted. What happens? They take it to legal at title, and they go, well, we need X, Y, and Z in there. And then the clients are yelling at me, and I was like, look, I tried so hard I knew this was going to happen, because I've got my legal stuff. I did my legal thing. The judge, if I didn't do my legal thing, the judge wouldn't have stamped it, right? I wouldn't have gotten exactly what I asked for. I knew there's some idiots that don't know how to do their job, or making issues, or they're looking at it weird, or, whatever it is. I think what we ended up doing, because I think I changed it how they wanted. But in that meantime, I got okay from one of my connections of my title to say, look, this is what I'm going to do. Tell me you're going to approve it. And they're like, yeah, we'll approve it. Don't worry about it. And so what did I have to do? I had to draft an emergency motion to amend the judgment. And Judge Hill was like, I just signed this. Like, why are you back? And I had to explain. I was like, blah, blah, blah. And she just stamped it. It was all good. But so this is one of those things where back to kind of what Alan was saying, and again, I do agree with Anastasia. There's probably a problem there, but making sure that you have relationships and you're not just going out there into the wild to go and find whoever. Everyone's got their own things they want to accomplish, whether it's hitting their numbers or showing off to someone or whatever it is. But if we're working together, and that's why associations like this are so important, we really do have to rely on each other, because things are going to happen. Stuff's going to go sour. Like we're all on the same team. Like I look at it as realtors and I are on the same team. We're professionals accomplishing totally different goals. I can't do what the real. I have clients who come to me and they're like, Blake, can you draft a lease, commercial lease or whatever? And I say, go talk to a leasing agent. Like, you don't want to pay me hourly to do that. Go and pay their fee. Do it their way. They have the forms. They know them. I can help do specifics if we want specific things on it, but you don't want to pay me. We turn those away. I'm like, I don't. You don't want it that way. And so the same with you, right? When you've got clients that are coming to you and they're asking you all these uncomfortable questions, and again, I want to make certain that it's okay to say it depends. I've said it to you guys so many. I said it to Alan. I'll say it to Chanel. I'm sure like 100 more times in my life, and we'll keep doing it. But it's okay, because anybody who pushes back on it, and I've had it where they say, "Oh, you don't know, you don't feel confident," and I'm like, you know what? I don't think we're a good fit, because you don't. There's so many moving parts, so many things that we just got to make sure we're on the same page on, that we should have that trust to say, I don't know. You guys are entering into escrow. You can't even guarantee it's going to go through. You should be having those conversations with clients that's okay, that we're going to work through it. We're going to do our best. But there's so many idiots out there. And, when the mortgage rates are going crazy, or they get a better offer and they're going to find ways to get out of the deal, what I would encourage you to say is, look, we know lawyers who could step in and do this and fight for that earnest money deposit and get this thing done, or enforce it by specific performance if we need to. Those are the things I want you to be able to have, those honest conversations with clients. And if they're not willing to have those conversations with you, again, you can kind of see the writing on the wall. Still buyer agent. Yeah. So yeah, thanks Anastasia. Thanks for that. Okay, I worked in a couple more horror stories. Any other questions? Anybody else want to hear me say it depends and punt on it and not give you the answer you're looking for? So like I said, the way that we work, again, with your clients, you're thinking about ways to get us involved. You think of coming today as a way to reach back out to your clients. I heard this horror story. Maybe you thought of them, or maybe you're just like, shoot, I remember, you're the girlfriend in this case. Like, oh man, what happens if he cheats on you? What are you guys going to do? You should be putting that stuff into writing. Say what the understandings are if you have a falling out, X, Y, and Z. For what we do, if we want to be putting stuff into, into a trust, if it's a young family that don't have kids, if you've got the joint tenancy, you're probably good. Once you start having kids and they start getting of age and stuff, you really got to make sure. The question I ask is, hey, if you've got kids, I'm like, yeah, we got the joint tenancy. One of us dies, it's no big deal. Okay, if both of you die, who's taking care of the kids? Are both sets of grandparents going to fight over it? And they're like, no, it'll be this one. And I'm like, okay, but what if the other one wants it? What if the local ones don't have the money and time to do it, and the ones on the East Coast do, but then you're yanking the kids out of school, moving to the East Coast? Like, I try to think of, I'm like the party pooper. Okay, I'm always the one who's got to be cynical and talk about when the stuff hits the fan. That's why you guys are here, right? Litigation horror stories, because this is when the lawyers have to get involved. And so hopefully we can have these conversations before the stuff hits the fan, and we could think about putting the estate plan together. Flat fees, the way we do it here, we do them for flat fees generally between 3,500 and 4,500, but it depends, right? It depends on how many properties, depends on how many people, it depends. There's just things, that's the general idea. And then if you've got you know, if you've got clients that are, you know, that are, if you get approached and you've got and a lot of people like to do this. Like, I was named trustee. I don't got to get a lawyer involved. It's our inheritance. Why am I going to be handing off money to Blake to do what I can do? I will be involved at some point, because they will screw something up. They won't give a proper notice. They won't give a proper accounting. They won't do what they need to do, and someone's going to get pissed off about it, and it's going to be a setup. So if you've got a client who comes in and is like, hey, you know, my mom died, I'm selling this property, I'm the trustee, I want to engage you to do stuff, you should be talking with them about they should not be doing it on their own. They should be talking to a professional, you, the realtor, to do the sale, certainly, but to make sure giving the proper disclosures. And you often want to pay the attorney to minimize if someone comes at you and drags you into court on a lawyer will bring you in on a contingency and say, you know, let's, you're going to pay me to shut up, or you're going to pay to fight me. Like, what do you want to do? So I'd encourage you to have those conversations with your clients before something happens. You know, just come in for a consult. We could look at it. I'll always say you need an attorney to represent you in a trust administration, because you just cannot believe how things get. I told some of the stories, so maybe you believe me better, but just the way people act and how entitled they are, it's just mind-boggling. And some of them would just rather burn it down than because now mom and dad aren't here to scold them, burn it down than let the other one feel like they won. It was like the lady who was like, oh yeah, I'll sign the deed, and then brings in this terrible offer. I'm trying to charge my girl rent to live in her own home that she's going to inherit, that the sister sat on for 2 years. You know, the lawyers made some money off of that, but it's out there. So again, that one too, you know, if you're thinking about, if you've got income properties or whatever, you got your own stuff, think about, you know, who you're going to give it to and when. Think about milestones when they hit certain ages. If you got kids, this is stuff that, you know, for you, these are awkward. These can be awkward conversations for you to have with clients, but these are ones I have awkward conversations with my clients all the time. So I'm happy to have them. All right, so we're almost 11. Is there anything else? Anything else to know?
We don't have any more questions. Blake, how can the attendees get a hold of you?
Yeah, I'll put into the chat. I know, and of course you have it, but I'll put in the chat. Usually email is best, bslater@stonesalaslaw.com. And what I often say, if you guys have an issue or you're going to bring someone my way, let's talk before I talk with the client, right? So, because let's think about like what my role is and what you want me to be, and we can kind of, and I just put my information. We can kind of game plan on, you know, what the approach is. But I also want to make sure, like, again, if you guys are bringing work my way, I want to make sure that whatever I'm doing, that we're all on the same page. You know, we're going to make sure that we're pushing through with the sale, but also that we're doing the right understanding of what's going on. So usually the call to me first before putting me on with the client is good. I do 20-minute intro calls for free. If you're in the middle of a transaction, if Alan hits me up, you know, we have to do a consultation. I'm going to have to look at it. I'm going to charge for it. You know, my hourly rate, which is $5.50. But again, that'll all be up front to do that. But I could do these things like we're doing now. You know, just give me a call at the office. I'd be happy to try and help.
Perfect. Well, seeing no other questions, make sure to take down Blake's information. He's a wealth of knowledge and definitely involved in the industry, so he can help if you're in a sticky situation. On that note, it's 11 o'clock right up. So thank you so much, Blake, for your time, and thanks everyone for attending.
Thanks, gang. Thanks, Chanel. Have a good one, everybody.